Thank you very much. I'm going to turn now to someone who spent a whole lot of time on this, and thank you for your leadership and co-sponsorship of the bill. Senator Gillibrand.
Thank you. Thank you, Chairman Benham, for being here, and thank you for taking the committee through what happened here and what role the CFTC has played and could play in the future. And I want to drill down on a couple areas where I still see risks that are coming ahead. I think you've made it very clear to the committee that comprehensive legislation is necessary. Senator Lummis and I wrote a very broad bill for all committees of jurisdiction, including the Banking Committee, including the Finance Committee, including the Intelligence Committee. But what the Ag Committee has done is focused on your jurisdiction, and this bill that the chairman and ranking member have put together is quite comprehensive. And I will be very grateful for you to give us the guidance about how to improve that, as well as the framework bill that Cynthia Lummis and I put together. I'm very concerned about the issues that you've talked about today, and I'm very concerned specifically with the potential of future problems. So responsible governance is something that we've talked a lot about today, and the absence of which really contributed to the FTX's debacle, especially its foreign registered entity. So for Senator Grassley, the difference between the foreign entity and the U.S.-based entity isn't necessarily clear. So I'm on the Intelligence Committee, and so I'm very concerned about who owns and who controls our critical infrastructure, such as platforms engaging in financial exchange and custodial services. My concern is particularly acute where foreign interests may conflict with those of the United States, and of course the FTX debacle has shown bad actors, foreign and domestic, can contribute to global digital asset markets' nefarious ends, harming United States consumers. The CFTC's current rules, I understand, provide that where ownership of the CFTC licensed exchanges changes at the holding company level, as when FTX US purchased the CFTC registered Ledger X digital asset derivatives exchange last year, the registrant has to notify the CFTC of the change of control. The Commission's current rules do not require detailed information about purchasing entity or its beneficial owners, nor do the current rules allow the Commission, where appropriate, to require conditions to the transaction to manage risk or to block the sale in exceptional circumstances. So, for example, if a hypothetical Chinese actor wants to acquire this entity who has questionable background and perhaps criminal activity undisclosed, this is something that the CFTC should be able to inquire about. So specifically, please tell us how you would address these issues under our legislation for digital asset platforms, particularly those that actually serve retail markets.
Thanks, Senator Gillibrand. An extremely important question, and you rightfully point out the existing authority for the Commission to ask questions about an acquisition or some sort of corporate combination is limited. It is essentially a notice filing at best. Given the circumstances of the recent weeks, and this is not an issue that is infrequent for the CFTC. We see a lot of consolidation and M&A activity in the derivative space. I think it's an important issue, particularly with your interests around cyber and critical infrastructure. And this is not unlike the CFIUS process in some respects, which this committee has been very focused on over the years. What can we do to strengthen that authority for the CFTC to be able to ask questions, to be able to demand books and records, to be able to demand information about personnel, management, system safeguards, going to your cyber issue, so that we can better screen and evaluate the acquiring company and what role or impact it might have on the CFTC regulated entity.
And then to follow on Senator Grassley's line of questioning about the undisclosed conflicts of interest, obviously Sam Bankman-Fried had several other entities that were double dealing or using assets that should have been not located in an area where he could have used them. We had allegations of inadequate books and records. We have allegations of how FTX's own tokens were reportedly used as collateral by customers and affiliated entities for massive loans. So these are just enormose numbers of conflicts of interest that will be investigated. Please describe under the proposed legislation by both Senator Boozman and Senator Stabenow, as well as the more framework-oriented bill with Cynthia Lummis, how the CFTC would address these conflicts and does that legislation provide the Commission with sufficient leeway to ensure identification, mitigation, disclosure, and where appropriate, prohibition of these conflicts?
Senator, this goes to the heart of market regulation. I've mentioned this before, these issues that you rightfully point out around conflicts of interest, about custody of funds, about books and records to examine, about financial resources to make sure that an entity has financial resources to be a going concern over a period of time. I think that the current bill is very effective in addressing nearly all of these issues. As I said to Senator Grassley, I think it's important that we tighten the conflicts of interest provisions because of the egregious nature of what we learned with FTX. And I think there's a way to do that. Disclosures to customers about financial resources also will be an important issue to address, and certainly look forward to working with you on that. In terms of authority and our experience at the CFTC, when we're able to impose these requirements on a regulated entity, it is quite workable and effective. And I will use the Ledger X entity as an example. On a daily basis, we know where the customer money is. And we don't have to go through Ledger X. We go directly to the custodian with direct access to know and identify the customer money. Books and records, on demand, we are able to examine books and records. These are just some examples of the direct relationship that regulation provides. And I think in the case of crypto and the bill DCCPA and your bill with Senator Lummis, these would be the authorities we have, and we could impose them and bring much more transparency to these unregulated entities.
Okay, so I have one last question that you may not know the answer to. But in your testimony, you just said that you thought that approximately 2% of FTX's customers of the international entity were U.S. persons. And so that would lead me to understand that either FTX lied or were untruthful about their business, and they actually should have been registered with the CFTC or the SEC under current rules and subject to CFTC's fraud and manipulation authority. So how can the CFTC investigate more aggressively to deploy its current enforcement authority where overseas exchanges in fact have such significant and actual business within the U.S., putting U.S. persons and the U.S. economy and other entities at risk?
Thank you, Senator. So I'm happy to share this with the committee, but this was a disclosure document made by John Ray yesterday. It's a pie chart, and it says, where the lost customer money is across the globe. There's huge amounts of money in some sort of island jurisdictions. 2%, there's a sliver from the U.S. I feel fairly confident there are a number of U.S.-based entities that have entities registered offshore that we're trading and will have exposure, and that's a huge issue. We should always think about institutions that have offshore entities that could potentially bring risk back to the U.S. From a retail perspective, and this is just my understanding, I've heard this for a number of years, some savvy retail investors are able to go around the virtual private networks, these VPNs that are essentially act as the firewall for an activity that happens offshore. That's an area that we could potentially look at. I don't know if it's an area that the CFTC has the expertise to look at, but perhaps we can work with other federal agencies to see how we can protect those firewalls and prohibit U.S. customers from getting around those prohibitions.
And I think this issue is one that the committee needs to understand. When you have a foreign registered entity, there are limitations about what we can actually regulate and how we can provide the oversight and accountability. But the examples that I brought up today are examples that could impact other businesses. So that's why I would like you to do some deep thinking about, in this particular market of digital assets, where there is always these workarounds and these abilities to get access to different markets, and then the related lack of registration where there should be, it's going to be something that you will have to wrestle with. And I'm certain this committee wants to help, because if you've heard from every person's testimony here so far, their constituents are very nervous about how this impacts U.S. markets and how it impacts U.S. persons. So that's why I think the bill that the chairwoman and ranking member have put together for this committee is so essential. If we don't regulate this industry, we're going to see more collapses, more bankruptcies, and a head-in-the-sand approach is absolutely unacceptable. And so we are very eager to work with you on solutions.
Thank you, Senator.
Thank you very much.